Hi, everyone. Harry here to talk about the Supreme Court's opinion in the Rahimi case, the one of the five today that is by far the most important. It's important in and of itself, but also very important for how it's going to play out maybe over the years in internal court debates and push and pull about how to interpret the Constitution and in particular, the history and tradition test that the court is so fond of. All right, so the facts in the case are that a court took away, or the law, took away from Rahimi the right to own a gun after the finding that he was a domestic violence offender. And that sort of finding wasn't made normally in those terms at the founding or later. It's a relatively recent development. So the question that it provoked under the court's case law in the Second Amendment, especially the latest Bruin case in New York about concealed carry permits, was whether it was constitutional for a state to say if you've been adjudicated by a court to be a domestic violent offender, you can't possess a gun. And under the logic of Bruin, you could say, and one member of the court, want to guess, Justice Thomas did say that that's not what we would have done back at the founding or at the relevant time of history and tradition. So it is unconstitutional. But 8 members of the Supreme Court disagreed with Thomas and did make the commonsensical determination that, of course, you can keep somebody who is a domestic violent offender as determined by a court from having a gun. And it's almost inconceivable to consider the opposite holding, to consider if, Thomas's views had prevailed in his, I'm sure he sees as a very sort of punctilious, intellectually consistent view of the nation's history and tradition test that the court has favored. That general test, history and tradition, is really widespread. It basically is controlling in all unenumerated rights cases. Bruin and firearms were special because in Bruin, the court interpreted regulations that post-date the founding by a fair bit, post-date the Second Amendment, and used them to consider. And that was a whole different kind of wrinkle. But in general, this question of the existence, I think, is well settled, but the application of tests of tradition and history is huge, will be especially huge in very big cases with unsettled propositions of law. And after the holding itself, the headline of the case is the court in 18 different, well, there's only 9 of them, so I'm being hyperbolic, but in 6 or 7 different directions, literally, on how you apply a test of history and tradition. Okay, so let's just start with Chief Justice Roberts' opinion for the court, which all of them do join. And he says, look, if a court, they insist on that, finds a credible threat to the physical safety of someone, you can disarm that person. And he says that since the founding, it's been a well-established principle that you can stop physical harm directed at some particular target. Now, that's a little bit already, as you can see, playing the joints a little bit loosey-goosey. Thomas would say, well, there's no strict analog at the founding to the actual kinds of orders we now enter. Therefore, this shouldn't be done. And Roberts sensibly rejects that proposition, but he says it is consistent with the nation's tradition of firearm regulation. But what he says, and this is going to be the case in the little 2-word phrase that's going to dominate constitutional law in many areas going forward, is that what was done at the founding is, quote, relevantly similar, close quote, to what the states look to do now. So, okay, maybe we didn't have these exact domestic violence restraining orders in so many words, but they are relevantly similar. So that already is going to open up a huge line of argument in gun cases, but other cases where unenumerated rights are at issue, including abortion, about what relevantly similar means. So when one side says, we didn't used to regulate this, the other side will be able to say, but it's relevantly similar to what you used to regulate. For example, is contraception, the permission of contraception, is that relevantly similar to a finding that there's a constitutional right for abortion? I mean, you can play this out anywhere where unenumerated rights come to the fore, and that's going to be, it loosens up the Bruin test, but I think in a way that will really resonate across the board in constitutional interpretation, where it's not a constitutional term, but so-called unenumerated. Okay. But he says relevantly similar, just put that down. Anyone going to law school at the front of their constitutional law notebook. Also says it's common sense. So it's not identical to what we used to have, but it needn't be. It's relevantly similar. And there you go. And that's the opinion for the court. Okay. But thereafter you have 1, 2, 3, 4, 5, 6, I think, separate opinions that really display a, fine-grained and nuanced, but it's the nuances that are really critical in this area. Differences of opinion with the court. This is going to be something that's going to be worked out over years. And so many people have now staked out their individual positions that you can imagine they will hew to. And this fight is going to be robust and multidimensional and hugely important. Okay, so Sotomayor and joined by Kagan says, look, this only makes sense because now the court, yes, they're looking at history, but it's calibrated to reveal something that's transferable to the present day. It just can't be this wooden kind of approach that was it there or was it not? You need something that is transferable, and that's their kind of way of getting at relevantly similar. Maybe you would say that's a little bit more capacious. Justice Gorsuch agrees with Roberts, but goes the other direction. He's really hard-nosed on the sense of it's really got to be clearly done in history. And this will be the other big phrase you'll hear about, is he says the Constitution, exactly what Roberts says it is not, is in fact trapped in amber. That is frozen for all time as of when it's enacted. And therefore you have to really, really be serious and constrained in your adjudication of history and how that history test happens. And you have to really, he's much more starchy, even as he agrees. He's next only to Thomas in saying this test still has a lot of teeth, and let's not get loosey-goosey with relevantly similar. Justice Kavanaugh, in some ways, stakes out a claim that's the most revolutionary or reactionary. He says, you know what? When you balance different kinds of interests, that gives too much room for courts to do policy determinations. When do you do that? Always, when you're talking about levels of scrutiny. He is staking a claim for getting rid of something that, as he says, is, relatively new in our history, but that is to say about 70 years old from the 50s, but levels of scrutiny, strict scrutiny, rational basis, intermediate scrutiny. This is a stunning suggestion, and I think he's thought it through, and you're going to hear him say it again and again. We shouldn't be in the business of strict scrutiny. We should just be making straight up judgments without calibrating or adjusting the scales in advance. Justice Jackson makes a big point of how Bruin, that test hasn't been workable, and you should reconsider the whole thing. And then that leaves Justice Barrett, who to my mind is the most interesting and sophisticated in a way, because she really zeroes in on what is tricky and pivotal in a history and tradition case, which is the level of generality with which you state the right in question. So this plays out all the time when you're talking about abortion. Are you looking at a right to terminate a pregnancy, or are you looking at a right to make decisions about family or childbirth? How general are you stating the right? There have been people in the past, Scalia was one, who said you should always state the right in the most narrow way possible. Barrett says, no, you've got to choose the right level of generality. And in this case, the court has chosen the right level of generality, preventing an individual who threatens physical harm and has been found by the court. That's the question, not do we do these kinds of orders in the past, or what could be more broadly preventing harm by anyone without a court finding. She says the court is right here because in this all important question of level of generality, they've zeroed in on the right test. Now, what makes it right? And how do you know when your level of generality is, Goldilocks precise? And we don't know. And she says we don't know. This will be something that if her view either prevails or just has a lot of influence in the court, there'll be all kinds of tussles over going forward. What do we mean under the Barrett view of the right level of generality and how you find it? So again, the case, very important. And just to consider that, otherwise there could have been people, domestic violent offenders found by a court permitted to have guns. That's imagine you're the victim or the ones who's been threatened there. That would have been atrocious. But more than that, much more than that, is a whole kind of multi-justice debate about how you should do history and tradition tests, which are the tests that are really important in all kinds of the most consequential and high profile cases that the court has, for example, abortion, but many more. So in that sense, it's the end of the term. So things haven't been settled, and yet different positions have been staked out that are going to be played out, I think, for years in really consequential ways. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.